your time is slightly different from mine. Thank you very much for inviting me. I hope you see my slides.
Yes.
Yeah, okay, that's fine. So I can start. So I've been very nicely introduced. I can go straight onto my presentation. And I do believe strongly that there are probably not too many differences between the Italian and the German style of looking at things. And insofar we are coming from the same, more or less the same legal family. Anyway, let's have a look at it. So two penalty clauses under German law are acting in terrorem, meaning they're really a kind of fine for not doing something. The object is to dissuade the party from breaching the contract or fear of the consequences of the breach. So this is the basic approach to the penalty idea. And initially the focus was very much on the purely compensatory function of penalty clauses, but this has changed, and there is an ongoing discussion from time to time whether or not it should have a purely fine goal, or whether it should have a kind of a compensatory effect as well. But this is not as important. It's just to better understand the ambiguity. True penalties are enforceable on the pacta sunt servanda principle. We don't have any problems in doing that. That's covered by law. Or as regard to contract to public policy, this is not an idea of German law so far. Stipulations like that are used enforced under Roman law. So far we are rooted in the same basic principles like the Italians. Damages are aimed at placing the innocent party in a position it would have occupied had the contract been performed. That's a totally different approach because now we look at the compensatory effect of a clause, not at law, but that is something which we can agree on. Contractual freedom does allow that. So penalties in terrorem are aimed at dissuading a party from breaching the contract, and the idea of damages, liquidated damages, is slightly different. You see here the old idea of Prussian law, which is more German than probably the civil code, which was set in force in 1900. Which was also done a kind of a guide for some parts of laws and of some laws in Far East, like in Korea, Japan, and China, partially. So we have had a definition therein, prior agreement on the compensable damages in the event of non-fulfillment of the main liability. Was the initial idea of Prussian law. And cannot be requested in addition to the main obligation, can be reduced by a judge. So the Prussian law was showing a bit the ambiguity because it's not clearly defined. Prior agreement on the compensable damages. This was the legal idea at the time, and the civil code has slightly changed that, but you see that both ideas have been rooted in German law. Are rooted in German law, though the current law is no longer really showing it. You just need to rely on contractual freedom. So we have here the basic provision in law, which we have with regard to penalties. And it says, well, the obligor promises the obligee in the event he fails to perform his obligation or fails to do so properly. That's second possibility. Payment of an amount of money as a penalty. The penalty is payable if he is in default. Is the performance owed consistent forbearance? The penalty is payable on breach. This is the idea in English on what has section 339 of the German Civil Code. The law on liquidated damages, however, is not codified. It derives from the principle of freedom of contract, basing underlying concepts which are rooted somewhere in the German consumer protection law. because German law, just a kind of additional explanation. German law is basically what we have put in place in 1900, plus some changes over the years. But we have introduced some time ago already an idea of consumer protection law, which was then in the 2000s introduced into the civil code. And it has an impact on all type of B2B contracts as well, not only on consumer protection law, because the courts and the law do support that. That supports that. The courts simply say that what the Consumer Protection Act and laws propose, so far it can be understood as a kind of a basic principle, should be applicable throughout the whole law. And if you totally deviate from these general ideas, then a particular contract provision may not be enforceable. So far, the consumer protection law in Germany is always present and important as a means of interpretation, guidance. And you see here that in April 2010, we have had a court case from the German Federal Supreme Court, Federal Court of Justice, who held that the following clause in standard terms is enforceable. If the seller pursues damages, it amounts to 10% of the purchase price. The damages are to be fixed at a lower or higher level if the seller proves higher or the buyer proves lower damages. The point here was whether a court can always correct the penalties, which is a part of German law, or not. This also should apply to liquidated damages in a way. So if you can really show evidence that actually the actual damages are higher or lower, then you might have to open the door for a review. But in principle, the liquidated damages clauses will be enforceable. So we have here the idea of penalties in a schematic diagram. So that you might have a promise to pay a penalty for non-performance. This is one idea. Or you have a promise for penalties for improper performance. The second case, you might have duplicity, because you may still claim performance of the other party, but you may on top claim the other penalties. This is the kind of let me say qualification in this regard. And you see on the right hand side an example. For instance, you might have delayed performance, or you may have bad performance, and in these cases you may have agreed on a penalty as well. In practice, we usually agree on penalties. We don't agree on liquidated damages. We talk about penalties, and the courts are frequently also inclined to say whatever looks like a penalty must be a penalty without looking at details, which is of course not really good. But this is a kind of actual current practice in Germany. So from time to time, there might be then also the desire to review an agreement on penalties, and then you might have to apply to reduce it. If it is disproportionate, it can be reduced. If it is proportionate, you can't. Whatever is proportionate or disproportionate is to be assessed on a case-by-case basis, but extremely high penalties are usually not acceptable, so the courts will interfere under normal circumstances. So in a summary, German law distinguishes between liquidated damages and contractual penalties. Liquidated damages are aimed at compensation for breach and are rooted in the party autonomy and contractual freedom. But these agreements are anyway subject to some control through the courts that may also be applicable in arbitration on a case-by-case basis. Penalty claims, according to Article 340 and subsequent, largely correspond to a tort claim, and under no conceivable point of view constitute remuneration in consideration of any service. So you have here a kind of approach as to the legal nature of penalties. It's a kind of fine for breach. The agreement on penalties make it easier to the obligee to pursue its claim for damages by releasing it from the individual burden to show the evidence for loss. This is also true regarding the idea of liquidated damages in a way. In addition to the penalty, the obligee can pursue unliquidated damages, but it must show the evidence in this regard. So the point regarding penalties is that they are not fully compensatory. You may agree on that. But to the extent they are too low, you might have an entitlement to claim more. So insofar, you will have to set off your entitlement to damages for breach of contract against the entitlement to the penalty, but only partially, as you can see here. So accumulating both is not permitted. You cannot ask a full penalty plus the idea of full liquidated damages or damages, unliquidated damages. Contractual penalty can only be offset against the claim for unliquidated damages if there is an identity of interest. This is, again, something to be looked at on a case-by-case basis. So you might have here one example, the additional claim for cost pursuing a claim might not be already covered, so you may claim it on top. And you have the references to Federal Supreme Court case law. So the difference between those is that penalties can be reduced if disproportionate or excessively high, 100%, 200%, something like that. Penalties do not limit the liability for breach. This is a difference which is obviously important, for instance, in international business, because if you look at the FIDIC forms of contract, then you see there subclause 8788, as the case may be. And they are in principle based on the English concept of liquidated damages, and they include, or they mean, a cap for liability regarding, for instance, delay. So the German answer to the idea of penalties would mean that there is no limitation. So there would be a dissimilarity with the contract wording under FIDIC, and it is my view that this dissimilarity shall be taken in account, and we should not prematurely make out of a liquidated damage clause under FIDIC a penalty clause under German laws. So you have been so kind in terms of the society to provide me with some questions, and here are my answers. Are liquidated damages prohibited under the law of Germany? No. They are not. We are totally in line with, for instance, also the Italian people, the French people. Should liquidated damages be provided for in the contract? Would they be interpreted as contractual delay penalties? The probability of this to happen is relatively high, but it is wrong. I've tried to explain that. The courts are frequently not really looking at it in very detail. They're not understanding what is really meant, what was agreed. And so they'll go prematurely by looking at words to an interpretation, while they should have probably looked at the particular wording and the conceptual basis thereof in order to avoid such a bad interpretation. Is there any limit on liquidated damages? German courts distinguish between bespoke contracts and standard terms, and regarding penalties, they normally say what is mentioned here: contractual penalty equal to 0.5% for each day of delay, but not more than 5% of the contract is not enforceable. It might be too high. So you will have to look at something which is slightly lower, in order to avoid that you finally fall within the authority of the court to review the clauses and to make them enforceable. Other courts and arbitrators in their country treat the liquidated damages clauses while they typically enforce it. If they're really aware of a liquidated damages clause, subject to some particular ideas regarding the basics of consumer protection law, which you have seen earlier. But basically, courts and arbitrators will apply the law the same, albeit arbitrators may exercise more discretionary powers. They are usually not looking at each detail regarding consumer protection law. They let it go. That's probably the most big difference. So I hope I could give you a small introduction into what we have set in force in terms of penalties and liquidated damages. If there is any question, please let me know. You do have my email address on the bottom of this slide. And I warmly thank you for having invited me to talk to you. Thank you.
Thank you so much, Dr.